Good morning, Michelle.
Good morning, sir. You are Joshua Barlow.
Yes, ma'am.
This is cause number 18-26688. Mr. Barlow is on probation for possession of a controlled substance. A motion has been filed. What is the announcement?
Judge, did a short reset on this one because we had a court date out in Harris County. Was in hopes that they would go ahead and dismiss that one then, but it looks like we will be moved to the trial docket. I believe they're going to try to subpoena the complainant over there. And so I don't know how long it's going to be or when, but
But it's
That's
understanding for Mr. Lewis, and I have no reason to doubt that based on my knowledge of that offense, Mr. Barlow, et cetera, that their subpoena of her will be against her will. And I don't intend to proceed on that with the court's permission in the motion under those set of circumstances, Judge, if that makes sense.
Right. And so do we, like, what are the other allegations? What's the?
If we could maybe at this juncture, knowing that, if we could just abandon or bypass those at this moment and have them enter pleas of true or not true just to the administrative violations, maybe get an update, see if there is for some reason any change in that before I formally abandon it. But it is my intention and it is my understanding based on the facts of that case that this subpoena of her, and correct me if I'm wrong, it's probably against her will.
right.
Over there, I mean, are we going to wait 3 years for him to go to misdemeanor trial?
No, we're doing it here. And if you want to get her here or try, that's one thing. If not, we're not waiting on that. So let's go ahead and go through the motion and get pleas of true or not true. And I will, it looks like, skip number 1, number 2, just those 2. It looks like it have to do with that other case. Okay. Mr. Barlow, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. And will he waive the formal reading of the motion?
You will, Judge.
Did this done real quick. Hold on. Sorry. All right, Mr. Barlow, in cause number 17-26688, I have a motion to revoke your community supervision. Shows that you were placed on probation September 18th of 2017 for the offense of possession of a controlled substance, a second-degree felony. That was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, Texas, November 8th of 2025. And that was without permission of Jefferson County probation. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 4 alleges that you failed to immediately report to the Community Supervision Department an up-to-date physical address. And is that true or not true?
That I didn't.
That you didn't tell them a new address
It's not true.
where you were living. Okay. Count 5 alleges that you failed to immediately report to the probation department your arrest from November 8th of 2025. Is that true or not true?
True.
Count 6 alleges that you provided a urine sample March 4th of 2025 and April 8th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Can you say what?
Marijuana.
Oh, true.
Count 7 alleges that you're behind in your court-assessed fees as of November 19th of 2025 in the amount of $4,734. And is that true or not true?
True.
Did you enter your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for a sentencing hearing. We'll get an updated pre-sentence report, find out anything else about those cases in Harris County, and then we'll come back at that date for sentencing. Are you currently wearing a drug patch? Are you ordered to wear a drug patch? Before you leave today, I want you to have a seat in the jury box. We're going to get a drug test this morning. All right, have a seat. Actually, come over here first and get a thumbprint, and then have a seat for a drug test. Great, Mr. Barlow. I'm going to again reset your case for sentencing. Stop and talk to probation on your way out of the courtroom today to make sure she doesn't need anything from you, and then we'll come back later for sentencing. All right, ready to go, sir. Good morning, ma'am. Are you Brittany Davis?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She did.
Ms. Davis, in cause number 25 DCCR 1450, you're charged with the second-degree felony offense of assault on a peace officer, and that's from May 19th of 2025. And how do you plead to that charge?
Judge, it is a reduced charge.
Oh, I'm sorry.
Yes, Judge.
Y'all gotta
Sorry.
stop me before I get too far. Hold on a second. Let me withdraw everything I just said. So it's the Class A, just a regular assault.
Resistance arrest.
All right. It's pulled up right now. All right, so Ms. Davis, in cause number again 25-1450, the state's elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest, and that's for May 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State offense number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Davis is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you have a conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed and you'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sent to the Jefferson County Jail for up to 1 year. Understand? All right, I've handed you the trial court certification that shows you've waived your right to appeal since I followed the agreement. You need to stop and talk to probation or have a seat in the courtroom until she's ready to call you up. She's at that desk right there. So just watch for her to call your name. She'll go over your paperwork with you. All right. Bless you, ma'am. Thank you. Okay. Thank you, ma'am. Good morning, ma'am. Are you LaCaria Kirkwood? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Kirkwood, in cause number 25 DCCR 0190, you're charged with the state jail felony offense of unauthorized use of a vehicle from January 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Kirkwood is not competent?
No, Your Honor.
Any history or any reason not to waive that pre-sentence report since it's in state jail?
Yes.
All right, then, Ms. Kirkwood, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, understand the nature and the consequences of your plea. find sufficient evidence to find you guilty. However, I'm going to follow that agreement you made and defer all proceedings and place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you'll never have a felony conviction. The other side of that is if you violate any condition of your probation, you could be brought back into court, found guilty. So you would have the felony conviction and you could be sent to the state jail for up to 2 years. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Also, Ms. Kirkwood, especially on a state jail felony, if you do everything you're supposed to up front on that probation, get some community service hours done, make sure your fees are all paid up, there's no reason for you not to get off early. So it'll be up to you. You have to do it all right, but there's no reason for you to even have to do that whole 4 years if you get everything taken care of early, okay? You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. She's at that desk right over there. So listen for her to call your name, okay? Good luck to you, ma'am.
Take it.
Good morning. Are you Erin Riley?
Yes, ma'am.
And this is 25 DCCR 1194. Miss Riley's charged of assault of hospital personnel. And what is the announcement?
Your Honor, if we could have a little bit more time, Ms. Riley did provide me some documentation regarding her mental health status.
Okay.
This revolved around, that's why she was at the
Sure.
hospital that day, and I provided that documentation to the prosecutor. So we get some time to review that.
Sure. Any issues? All right. I'll just do a normal reset. Miss Riley, make sure you stay in touch with Ms. Holmes and she'll let you know what she discusses with Mr. Smith and then when your next court date is. Okay.
Okay.
You're free to go. And then, Ms. Holmes, you've got Kaylin Thornton
Yes, sir.
sentencing.
Never seen that man's out of breath.
All right, sir, you Marshall Chance.
Yes.
And Mr. Chance is here in cause number 26 DCCR 0370 and charged with aggravated assault with a deadly weapon. Mr. Gertz is the attorney. Mr. Eckhart's here for Mr. Gertz today and has filed a motion asking that I consider removing the GPS monitoring device because you're unable to get on the premises of work. Is that correct? There's an issue?
Yes, Judge. So since he's been on bond conditions, he's been on short-term leave. He is now in the process of trying to get back to work, and the facility will not let him work where he does, where his normal job duties require because he works around explosives. The GPS company, they've gone through efforts to see if the GPS company can verify the equipment as it's an industry term, intrinsically safe, meaning that it can withstand any elements that would potentially cause ignitable liquids to explode. So I think there's a lot of devices that cannot go into certain facilities because they are not deemed intrinsically safe, like cell phones and things like that. And the GPS monitoring company cannot verify that. So we're kind of at an impasse where he's either going to lose his job or we're going to have to figure out another way to monitor him.
All right. And just for the record, I am taking judicial notice of the court's file, review the probable cause affidavit as well, and that underlying offense. Mr. Smith, what's the state's position?
I don't, and I understand where they're coming from. I guess I don't have much of a position.
And Judge, just for the
A person might lose their job.
right, just for the court's
Well, I mean, I would too. However, there's obviously the allegations are very serious. Has there been any issue that you know of? Have you heard from the complaining witness?
Not that I've heard from, and not that I know of, Judge.
So here's what I want to do. I would like for you to get in touch with her prior to me ruling on this. And what I can do is we don't necessarily, if there's no issues with her and any contact, put it in an email between myself and you and Mr. Gertz, and I can make a ruling without having to come back to court. And I can do that a little quicker since we don't have a docket next Monday. If there is an issue, then obviously if we need to come back, we'll reset it just for a couple of weeks and come back and let everybody make that argument or bring her here or whatever we need to do. Okay.
Yes, ma'am.
All right. So stay in touch with Mr. Gertz. He'll be getting an email and we'll figure that out if there's any issues, and then I'll make a will for that. Okay.
Thank you, Judge.
Yes, sir.
This courtroom transcript covers several different criminal cases involving probation violations, guilty pleas, deferred probation agreements, and bond condition hearings. One defendant, Joshua Barlow, admitted to multiple probation violations including drug use, failing to report an arrest, leaving the county without permission, and unpaid fees, leading the judge to revoke probation pending sentencing. Other defendants, including Brittany Davis and Larry Kirkwood, pleaded guilty to reduced or lesser offenses and received deferred probation deals, giving them a chance to avoid permanent convictions if they successfully complete probation. Another case involving mental health concerns was postponed for further review, while a separate aggravated assault case focused on whether a defendant's GPS monitor should be removed so he could return to work around explosives. Throughout the hearings, the judge emphasized accountability, probation conditions, future consequences, and opportunities for rehabilitation.